Good morning, Professor. Welcome to our presentation on the case of Thomas versus Walmart Canada 2006. My name is Karmanpreet Kaur from Group F, and this is our group case law assignment. And I am pleased to introduce my other group mates Deepak Sani, Harshpreet Kaur, Ram Sharan, Tapur Taranpreet, and Ved Rajnikant Patel. So today I'm going to discuss the case between a visitor and a business. In this case, there was Charlie Mae Thomas, who is the plaintiff in this incident, and she came to Walmart to do some shoppings and got injured by falling from the ice clump, and the business Walmart Canada, who is the defendant. And the counsel for the plaintiff, Miss Thomas, was Richard, and for the defendant, it was David Garnett. Let's discuss the fact that what exactly happened that day. Over the course of this presentation, we will discuss how the court handled evidence, witness credibility, and legal precedent before reaching its decision. Ultimately, we will explore the rationale that led to the Walmart's successful defense. So, in this case, there was a lady named Charlie Mae Thomas who came to do shopping at the Walmart store on October 21, 2002, near nearly 2 p.m. with her 4-month daughter, with her mother named Duna Kitson, and with her brother named Robert Kitson. Um, During the visit, she accidentally slipped due to the ice clump set by her in the front of the store entrance and got injured her left knee, her wrist, and her low back. Her daughter was also on her back, but she didn't get injured. After that, she filed a complaint against the Walmart for her injuries she got by falling outside the store. Due to the ice chunk, she described that ice chunk was like a baseball, and falling from this resulted in damage to her wrist, knee, and back. After that, she stood up, she gathered herself, and went straight into the store to use the restroom. She reported the fall to the store employee, and her brother and her mother took care of the child. Miss Thomas was approached by a store employee that if she would like to report the accident to the store manager. She agreed. Then she spoke to the manager of the store, and his name was Russell Hogger. At about 3:30 in the afternoon, Mr. Russell Hogger took a statement from the Miss Thomas that what exactly happened to them. While she was explaining, in the meantime, assistant manager took some picture of the area as a source of evidence. Miss Thomas stated that there was an ice chunk like a baseball, but the employee denied it. That there was nothing like that. Assistant manager said there was a little bit snow, but not like that much. She can slipped it just due to her negligence while walking, but she exclaimed that no, there was an ice chunk which caused her to fall. Now, what happened after when the case went to the court? Did the court give more attention to the lady or to the Walmart? This is going to be explained by my other group member.
Wal-Mart denied negligence, maintaining its staff cleared snow and applied ice melt whenever necessary. Employees insisted the sidewalk was dry before Mr. Thomas felt spotted by photographs taken shortly afterwards. Environment Canada records short light rainfall followed by sub-freezing temperatures, conditions that could produce isolated ice. Nonetheless, Walmart believed there was no unusual danger at the store entrance. Mr. Thomas and her companions remained adamant that a sizable ice chunk caused her accident. The presence or origin of the alleged chunk was heavily disputed. The court examined whether Walmart was responsible, aware of any hazardous conditions at the entrance.
Further talking about issues in dispute. In this case, the key issue was whether Walmart neglected its responsibility to ensure safety by not addressing a potential danger, which was an ice chunk that Ms. Thomas claimed was hazardous. She argued that Walmart should have noticed and removed this ice while The retailer denied both the existence of the ice and any negligence on their part. Another important aspect was whether typical winter condition could automatically make Walmart liable or if was necessary to prove a specific defect. The court was reviewed Walmart's maintenance efforts like snow removal at night and inspections during the day to assess if they were sufficient. Ultimately, Ms. Thomas had the burden of proving that Walmart's actions fell short of what was considered reasonable care. In its ruling, the Saskatchewan Court of Queen's Bench found that there was no unusual danger present outside the Walmart's entrance. The court noted that the given typical winter condition in Saskatchewan, individuals should exercise reasonable caution, particularly since ice can form naturally. Walmart provided evidence of regular maintenance practices including snow removal, the application of ice melt, and checks to ensure the safe conditions. The court concluded that Walmart had no knowledge of nor any reason to suspect the existence of any baseball sized ice chunk. Therefore, it determined that Walmart did not violate its duty of care, which leads to the dismissal of Ms. Thomas' claim due to her failure to meet the burden of proof.
The Saskatchewan Court of Queen's Bench held that no unusual danger existed outside the Walmart's entrance. Observing winter sidewalk condition in Saskatchewan, the court found that people should be reasonably cautious, especially when ice might form naturally. Walmart's evidence showed consistent maintenance with staff clearing snow, applying ice melts, and verifying safe conditions. The court determined Walmart had neither knowledge nor reason to suspect my baseball sized ice chunks. As a result, it concluded Walmart did not breach its duty of care. The plaintiff failed to prove through reasonable evidence that an unpredictable risk existed along with Walmart's negligence combined to produce her fall incident. Before this case, Saskatchewan established a precedent that sidewalks with snow and ice from nature occurrence cannot be considered unusual hazard unless it can be proven that the occupier ignored a unknown hazard or contributed to it. Consequently, Miss Thomas failed to meet the burden of proof and court dismissed her claim against Walmart completely.
Rational Thomas v. Wal-Mart Canada in 2006 SKQB 484. The court ruling refused to identify a single ice piece mirroring baseball sized dimensions and as unusual danger because Saskatchewan's winter conditions include regular ice and snow which require cautious behaviors from pedestrians. The court applied the common law principle originally created in Indermore v. During the evaluation of occupier's duties, the occupier needs to use reasonable care to avoid unusual risk, Dames 1866, that the occupier both recognize along with risk they should recognize. Pertinent evidence indicated Walmart implemented systematic operations for snow and ice maintenance that relied on overnight staff for removal duties followed by daytime staff for ongoing checks. The plaintiff could not establish negligence from Walmart because the court determined the company took sufficient measure to maintain a safe entrance area. The court evaluated plaintiff's testimonies as unreliable because it's noticed inconsistencies including her brother's late addition of details about kicking an ice chunk. Evidence obtained Walmart staff as well as photographic data spotted the fact the entrance area stayed dry and free ice conditions. The court referred to past Saskatchewan court decision on sidewalk winter conditions such as Yvonne v. Archville and Kirby v. Fairbrand 1995, Spellisky v. Pilot Butte 1996, A judge of the Court of Appeal ruled in CA 9630000 that snow and ice is sidewalk during winter periods are not classified as ordinary dangers unless established as coming from structural flaws. Procedural evidence showed that absence of recurring on structure ice formatting during this case despite past instances of structural liability. Jobert v. Davidner striking evidence showed that Wal-Mart did not have any role in creating or managing the circumstances that lead the ice chunk at the Davidner because the building's water leak did not contribute to its formation. Dr. Thomas bore responsibility for his injury because he neglected to monitor where he walked carrying his baby seat during winter conditions. The distinctions between responsibility towards customer safety lies between conditions of a retail store, interiors versus exterior ground, as explained in the court decision Sebo v. Westfair Foods. The court distinguished between indoor spills as Westfair Foods, which required active monitoring from outdoor areas where business operators need to remove all winter related risks from the property. The court dismissed the case because the plaintiff failed to prove through sufficient evidence that Wal-Mart displayed negligence or that peculiar dangers threatened their customers. Thus, Wal-Mart received a legal victory.
Okay, so the slide is question and answer section. Thomas v. Wal-Mart, Canada, 2006. So first question is, what was the key legal issue in this case? So the answer is, the primary legal issue was whether Wal-Mart, Canada breached its duty of a case by failing to prevent an unusual danger outside in its store, thereby causing Mr. Thomas slip and fall injury. Second question is, why did the court rule in favor of Walmart? The court ruled in Walmart favor because the plaintiffs failed to prove that an unusual danger exists. The court found that Walmart had reasonable maintenance procedures in place and that ice and snow in winter conditions do not inherit consistent and unusual danger under Saskatchewan law. Third question is, what legal standard did the court apply to determine Walmart liability? The court applied common law occupation liability principle, particularly and standard from Andermove v. Dems 1866, which state that an occupier must take a reasonable care to prevent injury from unusual dangers that no or out to no exist. Fourth question is, how did the court assess the credibility of witness testimony? The court found inconsistent in the plaintiff's testimony, especially regarding her brother's late claim that he kicked an ice chunk. In contract, Walmart employees provide consistent account support by photographic evidence showing a dry and clean entrance. Fifth question is, what role did environmental condition play in the decision? So weather reports confirm that there had been light snowfall, but temperature remained below freezing. The court noted that minor ice chunks in the winter are common and do not necessarily consistent. An unusual danger is unless proven to be an precedence hazard. Okay, so the next slide, sixth question is, did Walmart's maintenance program meet legal standards? Yes, the court found that Walmart had a reasonable maintenance plan, including overnight snow removal, ice melt application, and periodic daytime inspection, fulfilling its duty of care. Seventh question is, how does this case compare to similar slip and fall cases? The court cites several Saskatchewan cases where ice and snow on sidewalks were not deemed unusual dangers. Unlike cases involving international hazards, the outdoor condition in this case did not create liability for Walmart. And next question is, what was the significance of the plaintiff's action in the ruling? The court found that Mr. Thomas did not take reasonable care for her own safety. particularly since she was crying and in fact the car seat. Her failure to look where she was tapping contributed to the court discussion to demise the claim. Ninth is what Walmart have been liable if the ice chunk was a recurring issue. Possibly if the plaintiff had shown that Walmart was aware of a recurring ice issue due to a structural defect, the court might have found an unusual danger exists and held Walmart liable. Next is what was the final outcome of the case? The Saskatchewan Court of Queen's Bench dismissed Mr. Thomas' claim, ruling that Walmart was not liable. The court also awarded costs to Walmart if demanded.
Thomas V. Walmart Canada included illustrates how courts apply occupies liability principles in slip and fall cases, particularly under Saskatchewan's winter conditions. The plaintiff failed to show that a specific unusual danger existed or the Walmart had knowledge of a hazard and discredited it. Instead, the court credited Walmart's proactive maintenance routine and found Mr. Thomas partially at fault for not watching her step. This outcome reinforced that business must maintain reasonable standards, but patrons also share responsibility for their own safety. The decision underscored the importance of the credibility evidence, consistent testimony, and through documentation is successfully defending negligence claims with confidence.